Chapter 1: Human Rights Violation and Redressal. Introduction to Human Rights. Human rights are essentially the rights of people. They are the rights that an individual can avail and enjoy by virtue of being born as a human being. In legal terms, human rights means the rights relating to life, liberty, equality, and dignity of an individual, guaranteed by the Constitution or embodied in the international covenants, and which are enforceable by courts in India. The Universal Declaration of Human Rights, UDHR 1948, defines human rights as rights derived from the inherent dignity of the human person. The human rights can be broadly classified into three groups: civil rights, political rights, and economic and social rights. Civil rights. In India, the civil rights are the fundamental rights guaranteed to all the citizens under the Constitution of India. They are the rights to fight against unfair treatment by the state and the society. They are the rights that uphold humanitarian values with the purpose of nurturing human dignity. The civil rights include right to equality, right to freedom of speech and expression, right to freedom of movement and residence, right to freedom of peaceful association, right to freedom of religion, right to fair trial, right to privacy, right to life, right to own property, etc. Political rights. The political rights are guaranteed only to citizens of the state. They enable the citizens to participate directly or indirectly in the working of the state. These rights enable citizens to live in a society with law and order. The political rights can also be classified as civil rights as they ensure freedom to live in a society. Some of the political rights include right to nationality, right to criticize the government, right to hold public office, right to vote, right to represent or stand in election, etc. Economic and social rights. The economic and social rights make an individual self-sufficient and self-reliant in his/her basic needs: food, clothing, and shelter. These rights enable members of the society to attain economic and social equality. The economic and social rights focus on economic and social upliftment of the poor and weaker sections of society. Some of these rights include right to work, right to just conditions of work, right to equal pay for equal work, right to social security, right to health, right to education, etc. Types and nature of human rights violation. The human rights aim at protection of citizens and also at prevention of violations of human rights. But there are shocking acts of communal violence, child abuse, gender bias, caste-related atrocities, and so on, mainly due to poor enforcement of laws, cheap politics, and poor governance. Roman numeral 1. Violations of human rights of scheduled castes. Article 341 and 342 of Constitution of India have reference to scheduled castes and scheduled tribes with respect to any state or union territory. The SC/ST are the backward class of citizen disadvantaged people in India. The SCs belong to religions like Hinduism, Neo-Buddhism, and Sikhs. There is no religious bar as far as ST is concerned. That is, ST can belong to any religion. The Constitution of India, Article 366, 24, defines scheduled castes means Such castes, races, or tribes or parts of or groups within such castes, races, or tribes as are deemed under Article 341 to be scheduled castes for the purpose of this Constitution. Types of violations. Despite the constitutional framework, there are gross violations of human rights of SCs, especially by the upper caste people. Some of the violations are as follows. Point 1. Parading nude or with the painted face or body, thereby insulting the human dignity of SCs. In October 2006, a mob of 60 upper caste villagers stormed of the house of both Mangas in Karalangi village in Bandra, district of Maharashtra. 40-year-old Sureka, her daughter Priyanka, and sons Roshan and Sudhir were dragged from their home, stripped naked, beaten, and taken to the village square. At the village square, both women were raped for over an hour, after which all 4 family members were hacked to death. Point 2. Forcibly evicting the SCs from his or her land or premises and or interfering with the enjoyment of his/her rights over any land, premises, or water. Point 3. Forcing the SCs to work as a beggar or other forms of forced or bonded labor. For instance, most bonded laborers are low caste, illiterate, and extremely poor, while the employers are usually higher caste, literate, comparatively wealthy, and relatively more powerful members of the society. According to one estimate, 87% of bonded laborers are scheduled castes and scheduled tribes. Point 4. Inhuman acts with the intention to cause injury, insult, or annoyance to the members of SC community, such as dumping of excreta, waste matter, carcasses of dead animals, etc. Point 5. Forcing a member of SCs to drink or eat any inedible or obnoxious substance such as urine, dead animals, rotten vegetables, food grains, etc. Point 6. Assault on women belonging to the SCs with an intention to dishonor or outrage her modesty. For example, in April 2001, Ashama, a 40-year-old Dalit Jogini from Mahabubnagar district, Andhra Pradesh, was physically attacked and verbally abused after she entered into the village temple as part of the state government's anti-untouchability drive. The temple was initially washed with milk and later destroyed due to her allegedly polluting the temple. She received no government compensation and the new temple remains barred to Dalits. Point 7. Forcefully voting in favor of a particular candidate in a manner other than that provided by the law. At times, SCs are denied from voting. For instance, Munna Lal, belonging to SC, was beaten to death in Agra in March 2012, reportedly for refusing to vote for a particular party candidate during the elections to the State Assembly of UP. Point 8. Insulting a member of SCs with the intention to humiliate in any place within public view, including at the workplace. Although the Constitution of India does not permit such activities, but such cases do happen in several parts of India. Point 9. Burning of houses or property belonging to the members of SCs. For instance, caste atrocity in Latur, Bolangir district of Orissa More than 50 houses were burned by the upper castes in January 2012. Roman numeral 2. Violations of human rights of scheduled tribes. The Constitution of India, Article 366(25), defines scheduled tribes as such tribes or tribal communities or parts of or groups within such tribes or tribal communities are as deemed under Article 342 to the scheduled tribes for the purpose of this constitution. In India, the human rights situation of the tribals is grim. Since independence, tribals are victims of development and encroachments by non-tribals. The tribals face a high degree of poverty. Point 1. Victimization of Naxalites. According to the Ministry of Home Affairs, 21 out of the 28 states are afflicted by armed conflict, and majority of these states are afflicted by the Naxalite conflicts. The Naxals are active mainly in the tribal belts in mainland India. Neither the Naxal movement is led by the tribals, nor do the demands of the Naxalites relate to the tribals. The tribals are the victims of the class war of the Naxalites. Roman numeral 3. Violations of human rights of women. The Constitution of India not only grants equality to women, but also empowers the state to adopt measures of positive discrimination in favor of women for neutralizing the cumulative socio-economic, education, and political disadvantages faced by them. Fundamental rights, among others, ensure equality before law, prohibits discrimination against any citizens on grounds of religion, race, caste, sex, or place of birth, and guarantee equality of opportunity to all citizens in matters relating to employment. Roman numeral 4. Human rights violation against children. The Constitution of India contains provisions for survival, development, and protection of children. Generally, an individual is considered as a child who has not attained the age of 15 years. Roman numeral 5. Violations of human rights of disabled persons. The Persons with Disabilities Act 1995 defines disability under Section 2, Part 1 as blindness, low vision, leprosy cured, hearing impairment, locomotory disability, mental retardation, and mental illness. Types of human rights violation. Despite legislative provisions, disabled persons are subject to human rights violation. Point 1. People with disabilities are especially vulnerable to abusive treatment and human rights violations. Due to misconceptions, prejudice, and social exclusion, people with disabilities are at great risk and are often victims of harassment, bullying, and violence. Point 2. People with disabilities can also be victims of sexual abuse, particularly if they have intellectual disabilities. Point 3. Within institutions such as mental care facilities or prisons, people with disabilities may be neglected, given inadequate care or accommodations, be restrained or secluded, and subjected to physical, mental, or sexual violence. Point 4. Also, in institutions, people with disabilities may be subject to abuse if they are given drugs or subject to medical procedures without giving free or informed consent, such as forced sterilization or abortions, surgeries or other interventions, and electroshock treatment. Point 5. Even in their own homes, people with disabilities are particularly vulnerable to being abused by caregivers, health professionals, or even family members. Point 6. Children with disabilities are less likely to attend schools. Children with disabilities are also discouraged from attending school by a lack of resources, teachers without adequate training, and certain physical barriers. Roman numeral 6. Violations of human rights of the elderly persons. Most developed world countries have accepted the chronological age of 65 years as a definition of elderly or older person. However, in developing countries like India, a person is considered elderly when he or she has reached the age of 60. Also, at the moment, there is no United Nations standard numerical criterion, but the UN agreed cutoff is 60 plus to refer to the older population. Types of violations of human rights of elderly. Points 1. Abuse and insults by children and other members of the family. Point 2. False implication in court cases, especially in dowry-related matters by the daughter-in-laws. Point 3. Denial of proper food, medical care, and shelter. Point 4. Threats to life for not meeting the demands of the children, such as in the case of sale of property, which is in the name of the parents. Point 5. Extracting physical labor from the parents even though their health condition may not permit to do so. Point 6. Denial of share in the sale proceeds of ancestral property or any other assets. Point 7. Physical assault by sons, daughters, daughter-in-laws, and even grandchildren. Point 8. Murders for getting property or other assets from the elderly, and so on. Point 9. Forcing the parents to beg on the streets. Point 10. Denial of access to the parents to enter their homes. Constitutional provisions protecting human rights. The Constitution of India classifies the fundamental human rights under 6 groups. 1. Right to equality. 2. Right to freedom. 3. Right against exploitation. 4. Right to freedom of religion. 5. Cultural and educational rights. 6. Right to constitutional remedies. Numeral 1. Right to equality. Right to equality is an important right under the Constitution. It is elaborated in 5 articles 14 to 18 of the Constitution, dealing with different but related aspects of equality. It is the principal foundation of all other rights and liberties and guarantees the following. Article 14. Equality before law. Under Article 14 of the Constitution, guarantees to all citizens of India equality before the law or equal protections of the laws of the country. Means that the state cannot discriminate against any individual on the basis of caste, creed, color, sex, religion, or place of birth. Legal equality cannot be enforced strictly, irrespective of the circumstances involved. If so, this can lead to perversion of justice. The judiciary has taken appropriate note of this. The Supreme Court, in interpreting the scope of this article in Charanjit Lal v. Union of India, 1950, elaborated upon 4 requirements for establishing legal equality. A. Equal protection means equal protection under equal circumstances. B. The state can make reasonable classification for purpose of legislation. C. Presumption of reasonableness is in favor of legislation. D. The burden of proof is on those who challenge the legislation. Article 15. Social equality and equal access to public areas. Article 16. Equality in matters of public employment. Article 16 of the Constitution lays down that the state cannot discriminate against anyone in the matters of public employment. But there are certain exceptions. Some relevant clauses are Article 16, Part 1 provides equal opportunity to all citizens relating to employment or appointment to any office under the state. Article 16, Part 2 prohibits the state to discriminate on grounds only of religion, race, caste, sex, place of birth, or any of them in respect of any employment. Article 16, Part 4 states that the state may reserve posts for members of backward classes, scheduled castes, or scheduled tribes, which are not adequately represented in the services under the state, so as to uplift the weaker sections of society. Article 17. Abolition of untouchability. Article 17 of the Constitution abolishes the practice of untouchability. Practice of untouchability is an offense, and anyone doing so is punishable by law. The Untouchability Offences Act of 1955, renamed to Protection of Civil Rights Act in 1976, provides penalties for preventing a person from entering a place of worship or from taking water from a tank or well. Article 17 is a charter of emancipation, freedom for 1/6 of Indian population from humiliation. The inspiration for this article came from the work done by Mahatma Gandhi and others for the upliftment of Harijans. Article 18. Abolition of titles. Article 18 of the Constitution prohibits the state from conferring any titles. Citizens of India cannot accept titles from a foreign state. The British government had created an aristocratic class known as Rai Bahadurs and Khan Bahadurs in India. These titles were also abolished. The titles are abolished as they create privileges and distinctions in the society. However, awards can be conferred on the citizens of India. Therefore, the awards of Bharat Ratna and Padma Vibhushan can be awarded by the state. The Supreme Court on 15 December 1995 uplifted the validity of such award. Roman numeral 2. Right to freedoms. The Constitution of India provides the right to freedom, given in Article 19, 20, 21, and 22, with the view of guaranteeing individual rights. Article 19. Fundamental freedoms. The right to freedom in Article 19 guarantees the following 6 freedoms. It states that all citizens of India shall have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations and unions, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, to practice any profession or to carry on any occupation, trade, or business. Article 19, Part 1. A. Freedom to speech and expression. Freedom of speech and expression enable an individual to participate in public activities. The phrase freedom of press has not been used in Article 19, but freedom of expression can be exercised through any medium of communication, and therefore it includes freedom of press. The right to freedom of speech and expression does not confer absolute right to speak or publish what one may think right. All citizens do have a right, but subject to reasonable restrictions that can be imposed by the state. The people of the state is only to impose reasonable restrictions on not to act arbitrarily. Reasonableness is subject to judicial review. There are 8 restrictions on the freedom of speech and expression on certain grounds. For example, the restriction on speech and expression aims at protecting the territorial integrity of India. It does not allow anyone to advocate the separation of any part of India from the Union of India. Article 20. Protection against convictions. Protection with respect to conviction for offenses is guaranteed under Article 20. Article 20 states, A. No one can be awarded punishment which is more than what the law of the land prescribes at that time. This legal axiom is based on the principle that no criminal law can be made retrospective. An act to be an offense, the essential condition is that it should have been an offense legally at the time of committing it. B. No person accused of any offense shall be compelled to be a witness against himself. Compulsion in this article refers to what in law is called duress, injury, beating, or unlawful imprisonment to make a person do something that he does not want to do. This article is known as a safeguard against self-incrimination. C. The other principle enshrined in this article is known as the principle of double jeopardy. That is, no person can be convicted twice for the same offense. This principle was first established in the Magna Carta. Article 21. Protection of life and personal liberty. Article 21 declares that no citizen can be denied his life and personal liberty except according to the procedure established by law. This means that a person's life and personal liberty can only be disputed if that person has committed a crime. However, the right to life does not include the right to die, and hence suicide or an attempt thereof is an offense. Article 21, Part A. Right to education. In 2002, through the Constitution, the 86th Amendment Act, Article 21, Part A, has incorporated in the Constitution. It made primary education as a fundamental right. Article 21A states, the state shall provide free and compulsory education to all the children of ages 6 to 14 years in such manner that state may by law determine. Article 45 Directive Principle in its original form is deleted as education is made a fundamental right. It is now substituted with provision for free childhood care and education to children below the age of 6 years. Article 45 now states the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Article 51A is also amended. In Article 51A of the Constitution, following clause is included. A parent or guardian is to provide opportunities for education to his child or ward between the age of 6 and 14 years. Article 22. Protection against arrest and detention. Article 22 is complementary to Article 21. Certain procedural safeguards are provided under Article 22. Rights of a person arrested under these circumstances include: A. No one can be arrested without being told the grounds for his arrest. B. If arrested, the person has the right to defend himself by a lawyer of his choice. C. An arrested citizen has to be brought before the nearest magistrate within 24 hours. D. An arrested person cannot be detained in custody beyond 24 hours except by the order of the magistrate. Roman numeral 3. Rights against exploitation. Article 23. Prohibition of human trafficking and beggar. The right against exploitation given in Article 23 provides for abolishing traffic in human beings and beggar and other similar forms of forced labors, like beggar, practiced in the past by landlords, has been declared a crime as punishable by law. Trafficking in human beings for the purpose of slave trade or prostitution is also prohibited by law. An exception is made in employment without payment for compulsory services for public purposes. Compulsory military conscription is covered by this provision. The Constitution uses the term trafficking in human beings, which is a broad term that can include any form of exploitation, such as exploitation of women and children, or the crippled, handicapped persons for immoral or other undesirable purposes. It can also include any form of slavery or forced labor. A particular system of forced labor prevalent in some parts of the country called as beggar is specially mentioned in order to bring it under the jurisdiction of law and to ensure that it is not continued as a customary practice. Practices like devadasi and bonded labor forced upon tenants who lost their land due to indebtedness are also coming under the scope of this clause. Article 24. Prohibition of child labor. Child labor is considered a gross violation of the spirit and provisions of the Constitution. Article 24 states, "No child below the age of 14 years shall be employed to work in any factory or mine, or engaged in any other hazardous employment." The farmers of the Constitution were of the view that the children are not abused and that they are not forced by economic conditions to do work unsuited to their age. Also, children should be given opportunities to develop in a healthy manner and in conditions of freedom and dignity. The prohibition imposed by this article is absolute and without exception. However, it is to be noted that the social situation, especially poverty, needs to be tackled in order that the principle may be implemented. Roman numeral 4. Right to freedom of religion. Right to freedom of religion, covered in Articles 25, 26, 27, and 28, provides religious freedom to all citizens of India. The objective of this right is to sustain the principle of secularism in India. According to the Constitution, all religions are equal before the state, and no religion shall be given reference over the other. Article 25 provides the right to freedom of religion, which entitles all persons to preach, practice, and propagate any religion of their choice. But it does not include a right to make forcible conversions. However, certain practices like wearing and carrying of kirpans in the profession of the Sikh religion can be restricted in the interest of public order, morality, and health. Article 26 states, "Subject to public order, morality, and health, even religious denomination or any section thereof shall have the rights to a. establish and maintain institutions for religious and charitable purposes, b. manage its own affairs in matters of religion, c. own and acquire movable and immovable property, and d. administer such property in accordance with law. Article 27 states, no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Article 28 provides that a state-run institution cannot impart education that is pro-religion. Roman numeral 5. Cultural and educational rights. As India is a country of many languages, religions, and cultures, the Constitution provides special measures in Article 29 and 30 to protect the rights of the minorities. Article 29. Protection of interest of minorities. This article states, a. any section of citizens residing in the territory of India or any thereof having a distinct language, script, and culture of its own have the right to conserve the same. b. No citizen shall be denied admission to any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. It must be noted that although the heading of this article uses the term minorities, but in the text of this article, the term minorities is not mentioned at all. This means the provision of this article is equally applicable to any section of citizens, whether minority or majority. Article 30 states, all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Under this article, minority is considered on the basis of religion or language. Any linguistic group becomes a minority in a state where the language is different. Such groups may need protection, and this article provides for that. Roman numeral 6. Right to constitutional remedies. Article 32. Right to constitutional remedies empowers the citizens to move a court of law in case of any denial of fundamental rights. For instance, in case of imprisonment, the citizen can ask the court to see if it is according to the provisions of the law of the country. If the court finds that it is not, the person will have to be freed. The procedure for asking the courts to preserve or safeguard the citizen's fundamental rights can be done in various ways. The courts can issue various kinds of writs. These writs are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. A. The writ of habeas corpus secures the freedom of a person under arbitrary arrest. B. The writ of mandamus is issued by the Supreme Court to an official ordering him to perform his duty. C. Writs of prohibition and certiorari are issued by a higher court to a lower court, forbidding the latter from exceeding its jurisdiction. D. The writ of quo warranto is to deal with anyone who usurps a position and is therefore to be ousted. It is to be noted that when a national or state emergency is declared, this right is suspended by the central government. Note to students, the syllabus specifically mentions for right to equality, right to freedom, and right against exploitation. Acts protecting human rights. The Prevention of Atrocities Against SC/ST Act 1989. In 1989, the Government of India enacted the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act in order to prevent atrocities against the Scheduled Caste and Scheduled Tribes. The purpose of this act was to prevent atrocities and help in societal inclusion of SC/STs into the society. According to the preamble of the SC/ST Act, it is an act to prevent the commission of offences of atrocities against them, to provide for special codes for the trial of such offences, and for the relief and rehabilitation of the victims of such offences. Offences and atrocities. 1. Whoever, not being a member of a scheduled caste or a scheduled tribe, commits offences shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 5 years with a fine. The offences include: 1. Forces a member of a scheduled caste or scheduled tribe to drink or eat any inedible or obnoxious substance. 2. Acts with the intent to injury, insult, or annoyance to any members of a scheduled caste or a scheduled tribe by dumping excreta, waste matter, carcasses, or any other obnoxious substance in his premises or neighborhood. 3. Forcibly removes clothes from the person of a member of a scheduled caste or a scheduled tribe, or parades him naked or with painted face or body, or commits any similar act which is derogatory to human dignity. 4. Wrongfully occupies or cultivates any land owned by or allotted to or notified by any competent authority to be allotted to a member of a scheduled caste or a scheduled tribe, or gets the land allotted to him transferred. 5. Wrongfully disposes a member of a scheduled caste or scheduled tribe from his land or premises, or interferes with the enjoyment of his rights over land, premises, or water. 6. Compels or entices a member of a scheduled caste or scheduled tribe to do beggar or other similar forms of forced or bonded labor, other than any compulsory service for public purposes imposed by government. 7. Forces or intimidates a member of a scheduled caste or a scheduled tribe not to vote or to vote for a particular candidate, or to vote in a manner other than that provided by law. 8. Institutes false, malicious, or vexatious suit or criminal or other legal proceedings against a member of a scheduled caste or a scheduled tribe. 9. Gives any false or frivolous information to any public servant, and thereby causes such public servant to use his lawful power to the injury or annoyance of a member of a scheduled caste or a scheduled tribe. 10. Intentionally insults or intimidates with intent to humiliate a member of a scheduled caste or a scheduled tribe in any place within public view. 11. Assaults or uses force to any woman belonging to a scheduled caste or a scheduled tribe with intent to dishonor or outrage her modesty. 12. Being in a position to dominate the will of a woman belonging to a scheduled caste or a scheduled tribe, and uses that position to exploit her sexually, to which she would not have otherwise agreed. 13. corrupts or fouls the water of any spring, reservoir, or any other source ordinarily used by members of the scheduled castes or the scheduled tribes, so as to render it less fit for the purpose for which it is ordinarily used. 14. Denies a member of a scheduled caste or a scheduled tribe any customary right to passage to a place of public resort, or obstructs such member so as to prevent him from using or having access to a place of public resort to which other members of public or any section thereof have a right to use or access to. 15. Forces or causes a member of scheduled caste or scheduled tribe to leave his house, village, or other place of residence. 2. Whoever, not being a member of a scheduled caste or scheduled tribes. Point 1. Gives or fabricates false evidence intending thereby to cause, or knowing it to be likely that he will thereby cause, any member of a scheduled caste or a scheduled tribe to be convicted of an offense which is capital offense by the law for the time being in force, shall be punished with imprisonment for life and with fine. And if an innocent member of a scheduled caste or a scheduled tribe be convicted and executed in consequence of such false or fabricated evidence, the person who gave or fabricated such false evidence shall be punished with death. Point 2. Gives or fabricates false evidence, intending thereby to cause, or knowing it to be likely that he will thereby cause, any member of a scheduled caste or a scheduled tribe to be convicted of an offense which is not capital, but punishable with imprisonment for a term of 7 years or upwards, shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 7 years or upwards, with fine. Point 3. Commits mischief by fire or any explosive substance, intending to cause, or knowing it to be likely that he will thereby cause damage to any property belonging to a member of a scheduled caste or a scheduled tribe, shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 7 years, and with fine. Point 4. Commits mischief by fire or any explosive substance, intending to cause, or knowing it to be likely that he will thereby cause destruction of any building which is ordinarily used as a place or worship, or as a place for human dwelling, or as a place for custody of the property by a member of a scheduled caste or a scheduled tribe, shall be punishable with imprisonment for life and with fine. Point 5. Commits any offense under the Indian Penal Code, is punishable with imprisonment for a term of 10 years or more against a person or property on the ground that such person is a member of a scheduled caste or a scheduled tribe, or such property belongs to such member, shall be punishable with imprisonment for life and with fine. Point 6. Knowingly or having reason to believe that an offense has been committed under this chapter, causes any evidence of the commission to that offense to disappear, with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offense which he knows or believes to be false, shall be punishable with the punishment provided for that offense. Or, point 7. Being a public servant, commits any offense under this section, shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to the punishment provided for that offense. Punishment for neglect of duties. Whoever being a public servant but not being a member of a scheduled caste or a scheduled tribe willfully neglects his duties required to be performed by him under this act shall be punishable with imprisonments for a term which shall not be less than 6 months, but which may extend to 1 year. Enhanced punishment for subsequent conviction. Whoever, having already been convicted of an offense under this chapter, is convicted for the second offense or any offense subsequent to the second offense shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to the punishment provided for that offense.
The Domestic Violence Act 2005. The Protection of Women from Domestic Violence Act 2005 was brought into force by the Government of India from October 26, 2006. The Act was passed by the Parliament in August 2005 and assented to by the President on September 13, 2005. Under this Act, any conduct of the respondent. Now, the respondent is any adult male person who is or has been in a domestic relationship with the aggrieved person and includes relatives of the husband or male partner. Now, any conduct of the respondent shall constitute domestic violence if he habitually assaults or makes the life of the aggrieved person miserable by cruelty of conduct, even if such conduct does not amount to physical ill treatment, or forces the aggrieved person to lead an immoral life, or otherwise injures or harms the aggrieved person. However, any conduct or act shall amount to domestic violence if the action of the respondent was reasonable for his own protection or for the protection of his or another's property. Scope. Primarily, this act is meant to provide protection to the wife or female live-in partner from domestic violence at the hands of the husband or male partner or his relatives. The law also extends its protection to women who are sisters, widows, or mothers, children, including adopted or step below the age of 18. Now, domestic violence under the Act includes actual abuse or the threat of abuse, whether physical, sexual, verbal, emotional, or economic. Harassment by way of unlawful dowry demands to the woman or her relatives would also be covered under this Act. The kinds of abuse covered under the Domestic Violence Act 2005 are: number 1, physical abuse, an act or conduct causing bodily pain, harm, or danger to life, limb, or health. An act that impairs the health or development of the aggrieved person, or just an act that amounts to assault, criminal intimidation, and criminal force. Sexual abuse, any conduct of a sexual nature that abuses, humiliates, degrades, or violates the dignity of a woman. Number 3, verbal and emotional abuse, any insult, ridicule, humiliation, name calling, or insults or ridicule for not having a child or a male child specifically, or repeated threats to cause physical pain to any person in whom the aggrieved person is interested. Number 4, economic abuse, depriving the aggrieved person of economic or financial resources to which she is entitled under any law or custom, or which she acquires out of necessity, such as household necessities, stridhan, her jointly or separately owned property, maintenance, and rental payments. So there were these 4 kind of abuses that are covered under the Domestic Violence Act: physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse. Now, the salient features. The salient features of the Protection from Domestic Violence Act 2005 are as follows. Number 1. The Act seeks to cover those women who are or have been in a relationship with the abuser where both parties have lived together in a shared household and are related by consanguinity, marriage, or a relationship in the nature of a marriage or adoption. In addition, relationship with family members living together as a joint family are also included. Even those women who are sisters, widows, mothers, single women, or living with the abuser are entitled to get legal protection under the proposed act. Second point, domestic violence includes actual abuse or the threat of abuse, that is physical, sexual, verbal, emotional, and economic. Harassment by way of unlawful dowry demands to the woman or her relatives would also be covered under this definition. Number 3, one of the most important features of this act is the woman's right to secure housing. Now, the act provides for the woman's right to reside in the matrimonial or shared household, whether or not she has any title or rights in the household. Mind you, she with every chance has a right to the household. Now, this right is secured by a residence order which is passed by the court. These residence orders cannot be passed against anyone who is a woman. Number 4, the other relief envisaged under the act is that of the power of court to pass protection orders that prevent the abuser from aiding committing an act of domestic violence or any other, specifically entering a workplace or any other frequently visited place by the abuser, attempting to communicate with the abused, isolating any assets owned by both the parties, and causing violence to the abused, her relatives, and others who provide her assistance from the domestic violence. Number 5, the Draft Act provides for appointment of protection officers, NGOs, to provide assistance to the women with reference to medical examination, legal aid, safe shelter, etc. Number 6, the Act provides for breach of protection order or interim protection order by the respondent as a cognizable and non-bailable offer, punishable with imprisonment for a term which may extend to 1 year or with fine which may extend to 20,000 rupees or even both. Similarly, non-compliance or discharge of duties by protection officer is also sought to be made an offence under the same with similar punishment. Liabilities and restriction imposed on the respondent. Number 1, he can be subjected to certain restrictions as contained in the protection and residence order against him. The respondent can be made accountable for providing money relief to the aggrieved person and her children and pay compensation damages as directed in the compensation order. Next, he has to follow the arrangements made by the court regarding custody of the child or children of the aggrieved person as specified in the custody order. Next, the Domestic Violence Act 2005 does not permit any female relative of the husband or male partner to file a complaint against the wife or female partner. Number 3, the Child Labor Prohibition and Regulation Act 1986. This is our next topic. This act was passed in 1986, the Child Labour Act, to prohibit the employment of children under certain occupations and to regulate the conditions of work for children under certain other occupations where they can be employed. According to this act, child means a person who has not completed 14 years of age. Prohibition of employment of children in certain occupations and processes. No child shall be employed or permitted to work in any of the following establishments or in process industries as stated in the act. Some of the establishments where child labor cannot be employed include transport of passengers, goods or mails by railway, work relating to selling of crackers and fireworks in shops with temporary licenses, abattoirs or slaughterhouses, automobile workshops and garages, foundries, handloom and powerloom industry, mines which are underground and underwater, and collieries, plastic units and fiberglass workshops, and so on. The process industries where child labor cannot be employed are beadi making, carpet weaving, cement manufacture including bagging of cement, cloth printing, dyeing and weaving, manufacture of matches, explosive and fireworks, soap or detergent manufacture, wool cleaning, building and construction industry, manufacturing processes using toxic metals and substances such as lead, mercury, manganese, chromium, cadmium, benzene, etc. All hazardous processes as stated under the Factories Act 1941, agarbatti manufacturing, brick kilns and roof tiles units, and such several other industries stated in the Act. Some important regulations are as follows. No child shall be required or permitted to work in any establishment in excess of such number of hours as may be prescribed for the establishment or class of establishments. Next, no child shall be permitted or required to work between 7 p.m. No child shall be required or permitted to work overtime. Every child shall be allowed in each week a holiday or one whole day. Every occupier or employer shall within 30 days send a written note in Form A to the inspector within whose local limits the establishment is situated. Every occupier or employer of an establishment shall maintain a register in respect of children employed or permitted to work in an establishment in Form B. Now, penalty. Violations under the Act shall be punishable with imprisonment of a few months to 2 years or with a fine of Rs 10,000 to 20,000 or both, depending upon the type of violation. Now, our next topic is Vishakha Guidelines for Preventing Sexual Harassment at Workplace 1997. So, this is our third act. The gang rape of Bhanwari Devi in 1992, a volunteer for a government initiative to stop child marriages in Rajasthan, was the immediate case of a public interest litigation. Now, the PIL was filed by several NGOs led by an NGO called Vishakha. So, Vishakha was leading all of them. Vishakha and social rights activists. They argued that there was a need for legal intervention to ensure the constitutional rights of women to work in a violence-free environment. The Vishakha judgment, issued by the Supreme Court of India in 1997 in response to the PIL, formulated a writ mandamus to all public and private sector institutions, directing them to institute in-house complaint mechanisms to tackle sexual harassment at a workplace. Vishakha Guidelines Against Sexual Harassment in the Workplace. Guidelines laid down by the Honorable Supreme Court in Vishakha and others versus State of Rajasthan and others. Number 1. Duty of the employer or other responsible persons in workplaces and other institutions. Now the duty is, it shall be the duty of the employer or other responsible persons in workplaces or other institutions to prevent or deter the commission of acts of sexual harassment and to provide the procedures for the resolution, settlement or prosecution of acts of sexual harassment by taking all steps required. Number 2. Definition of sexual harassment. For this purpose, sexual harassment includes such unwelcome sexually determined behavior, whether directly or by implication, as point 1, physical contact and advances, point 2, a demand or request for sexual favors, point 3, sexually colored remarks, point 4, showing pornography, point E, any other unwelcome physical, verbal or non-verbal conduct of sexual nature. Point 3 under Vishakha's guidelines in a workplace is preventive steps. All employers or persons in charge of workplace, whether in public or private sector, should take appropriate steps to prevent sexual harassment. Without prejudice to the generality of this obligation, they should take the following steps. Express prohibition of sexual harassment as defined above at the workplace should be notified, published and circulated in appropriate ways. The rules, regulations of government and public sector bodies relating to conduct and discipline should include rules, regulations prohibiting sexual harassment and provide for appropriate penalties in such rules against the offender. As regards private employers, steps should be taken to include the aforesaid prohibitions in the standing orders under the Industrial Employment Standing Orders Act 1946. Appropriate work conditions should be provided in respect to work, leisure, health and hygiene to further ensure that there is no hostile environment towards women at workplaces, and no employee woman should have reasonable grounds to believe that she is disadvantaged in connection with her employment. Number 4. Criminal proceedings. Where such conduct amounts to a specific offence under the Indian Penal Code or under any other law, the employer shall initiate appropriate action in accordance with law by making a complaint with the appropriate authority. In particular, it should ensure that victims or witnesses are not victimized or discriminated against while dealing with complaints of sexual harassment. The victims of sexual harassment should have the option to seek transfer of the perpetrator or their own transfer. Number 5. Disciplinary action. Where such conduct amounts to misconduct in employment as defined by the relevant service rules, appropriate disciplinary action should be initiated by the employer in accordance with those rules. Number 6. Complaint mechanism. Whether or not such conduct constitutes an offence under law or a breach of the service rules, an appropriate complaint mechanism should be created in the employer's organization for redress of the complaint made by the victim. Such complaint mechanism should ensure time-bound treatment of complaints. Number 7. Complaints Committee. The complaint mechanism referred to in 6th point above should be adequate to provide, where necessary, a complaints committee, a special counselor, or other support services, including the maintenance of confidentiality. The complaints committee should be headed by a woman, and not less than half of its members should be women. Further, to prevent the possibility of any undue pressure or influence from senior levels, such complaints committees should involve a third party, either an NGO or other body who is familiar with the issue of sexual harassment. Number 8. Workers' Initiative. Employees should be allowed to raise issues of sexual harassment at a workers' meeting and in other appropriate forum, and it should be affirmatively discussed in employer-employee meetings. Number 9. Awareness. Awareness of the rights of female employees in this regard should be created, in particular by prominently notifying the guidelines and appropriate legislation when enacted on the subject in a suitable manner. Number 10. Third-party harassment. Where sexual harassment occurs as a result of an act or omission by any third party or outsider, the employer and person in charge will take all steps necessary and reasonable to assist the affected person in terms of support and preventive action. Number 11. The central or state governments are requested to consider adopting suitable measures, including legislation, to ensure that the guidelines laid down by this order are also observed by the employers in private sector. Number 12. These guidelines will not prejudice any rights available under the Protection of Human Rights Act 1993. Our next topic is the persons with disabilities, equal opportunities, protection of rights, and full participation. Act 1995. The Person with Disabilities, Equal Opportunities, Protection of Rights, and Full Participation Act 1995 has come into enforcement on February 7, 1996. This law is an important landmark and is a significant step in the direction to ensure equal opportunities for people with disabilities and their full participation in the nation building. Disability includes blindness, low vision, leprosy cured, hearing impairment, locomotor disability, mental retardation, mental illness. The Act provides for both preventive and promotional aspects of rehabilitation like education, employment and vocational training, reservation, research and manpower development, creation of barrier-free environment, rehabilitation of persons with disability, unemployment, establishment of homes for persons with severe disability, etc. Main provisions of the Act. Number 1. Prevention and early detection of disabilities. Surveys, investigations and research shall be conducted ascertain the cause of occurrence of disabilities. Various measures shall be taken to prevent disabilities. States' primary health center shall be trained to assist in this area. All the children shall be screened once in a year for identifying at-risk cases. Awareness campaigns shall be launched and sponsored to disseminate information Measures shall be taken for prenatal, perinatal, and postnatal care of the mother and child. Number 2, education. Every child with disability shall have the right to free education till the age of 18 years in integrated schools or special schools. Appropriate transportation, removal of architectural barriers, restructuring of modifications in the examination centers shall be ensured for the benefit of children with disabilities. Children with disabilities shall have the right to free books, scholarships, uniform, and other learning material. Special schools for children with disabilities shall be equipped with vocational training facilities. Non-formal education shall be promoted for children with disabilities. Teachers' training institutions shall be established to develop requisite manpower. Parents may move to appropriate forum for the redressal grievances regarding the placement of their children with disabilities. Number 3, employment. 3% of vacancies in government employment shall be reserved for people with disabilities. 1% each for persons suffering from blindness or low vision, hearing impairment, locomotor disabilities, and cerebral palsy. Suitable schemes shall be formulated for the training and welfare of persons with disabilities, the relaxation of upper age limit, regulating the employment, health and safety measures, environment in places where persons with disabilities are employed. Government educational institutes and other educational institutes receiving grant from government shall reserve at least 3% seats for people with disabilities. No employee can be sacked or demoted if they become disabled during service, although they can be moved to another post with the same pay and condition. No promotion can be denied because of impairment. Number 4, affirmative action. Aids and appliances shall be made available to people with disabilities. Allotment of land shall be made at concessional rates to the people with disabilities for house, business, special recreational centers, special schools, research schools, factories by entrepreneurs with disability. Number 5, non-discrimination. Public building, rail compartments, buses, ships and aircrafts shall be designed to give easy access to disabled people. In all public places and in waiting rooms, toilets shall be made with chair accessible. Braille and sound symbols are also provided in lids. All the places of public utility shall be made barrier-free while providing ramps. Number 6, research and manpower development. Research in the following areas shall be sponsored and promoted: prevention of disability, rehabilitation including CBR, development of assistive devices, job identification, on-site modification of houses and factories. Financial assistance shall be made available to the universities or institutions of higher learning, professional bodies, and non-government research units or institutions for undertaking research for specified education, rehabilitation, and manpower development. Number 7, social security. Financial assistance to non-government organizations, rehabilitation of persons with disabilities, insurance coverage for the benefit of the government employees with disabilities, unemployment allowance to people with disabilities registered with the Special Employment Exchange for more than a year and who could not be placed in any gainful occupation. Number 8, grievance redressal. In case of violation of rights as prescribed in the Act, people with disabilities may move an application to Chief Commissioner for Persons with Disabilities in the Centre, Commissioner for Persons with Disabilities in the states. Our next topic is redressal mechanisms at the national and state levels. Number 1, National Human Rights Commission. The Government of India passed the Protection of Human Rights Act 1993. This act recommended for the setting up of a National Human Rights Commission along with the State Human Rights Commission in the states and human rights courts. These organizations were to work for the protection and promotion of human rights. Constitution of a National Human Rights Commission. The central government shall constitute a body to be known as the National Human Rights Commission to exercise the powers conferred upon and to perform the functions assigned to it under the Protection of Human Rights Act. The commission shall consist of a chairperson who has been a Chief Justice of the Supreme Court, one member who is or has been a judge of the Supreme Court, one member who is or has been the Chief Justice of a High Court, 2 members to be appointed from amongst persons having knowledge of or practical experience in matters relating to human rights. The chairperson of the National Commission for Minorities. There shall be a Secretary General who shall be the Chief Executive Officer of the Commission and shall exercise such powers and discharge functions of the Commission as may be delegated to him by the Commission or the chairperson as the case may be. The headquarters of the Commission shall be at Delhi, and the Commission may, with the previous approval of the central government, establish offices at other parts of India. Functions of the Commission. The Commission shall perform all or any of the following functions, namely: Number 1, inquire on its own or on a petition presented to it by a victim or any other person on his behalf, or on a direction or order of a court into complaint of violation of human rights or abatement thereof, or negligence in the prevention of such violation by a public servant. Number 2, intervene in any proceeding involving any allegation or violation of human rights pending before a court with the approval of such case. Number 3, visit any jail or other institution under the control of the state government where persons are detained or lodged for purposes such as treatment, reformation or protection, for the study of the living conditions of the inmates thereof and make recommendations there to the government. Next point, review the safeguards provided by or under the Constitution or a law for the protection of human rights and recommend measures for their effective implementation. Next point, review the factors including acts of terrorism that inhibit enjoyment of human rights and recommend appropriate remedies or measures. Next point, study treaties and other international instruments on human rights and make recommendations for their effective implementation. Next point, undertake and promote research in the field of human rights. Next, spread human rights literacy among various sections of society and promote awareness of the safeguards available for the protection of these rights through publications, the media, seminars and other available means. Next, encourage the efforts of non-governmental organizations and institutions working in the field of human rights. Next, such other functions as it may consider necessary for the protection of human rights. State Human Rights Commission. A state government may constitute a commission called Name of the State Human Rights Commission, like it's Maharashtra, right? So Maharashtra Human Rights Commission under the Protection of Human Rights Act 1993. Maharashtra was just an example. So the name of the state, Human Rights Commission. Okay. The state HRC shall exercise the powers conferred upon and perform the functions assigned in respect of promoting and protecting human rights. Composition of the Commission. The State Commission shall consist of a chairperson who has been a Chief Justice of a High Court, one member who is or has been a judge of a High Court or district judge in the state with a minimum of 7 years experience as a judge, one member to be appointed from amongst persons having knowledge of or practical experience in matters relating to human rights. There shall be a secretary who shall be the chief executive officer of the State Commission and shall exercise such powers and discharge such functions of the State Commission delegated to him. 2. Or more state governments may, with the consent of a chairperson or member of a State Commission, appoint such chairperson or, as the case may be, such member of another State Commission simultaneously if such chairperson or member consents to such appointment. The headquarters of the State Commission shall be at such place as that of state government, as that the state government may specify. A State Commission may inquire into violation of human rights only with respect of matters relating to any of the entries enumerated in List 2 and List 3 in the 7th schedule of the Constitution. Protection of action taken in good faith. No suit or other legal proceeding shall lie against the central government, state government, national commission, the State Commission, or a member thereof, or any person acting under the direction either of the central government, state government, commission, or the state commission, respect of anything which is in good faith done or intended to be done in pursuance of the Protection of Human Rights Act. The National Commission for Scheduled Tribes. The Statutory National Commission for Scheduled Castes and Scheduled Tribes came into being consequent upon passing of the Constitution since 5th Amendment Bill 1990. The first commission under the Constitution, 65th Amendment Act, was constituted in March 1992. Subsequently, another 3 such commissions were constituted. Consequent upon the Constitution, 89th Amendment Act, coming into force on 19th February 2004, the erstwhile National Commission of Scheduled Castes and Scheduled Tribes has been replaced by National Commission for Scheduled Castes and National Commission for Scheduled Tribes. They are now separated for Scheduled Castes and Scheduled Tribes. Okay. So, functions of the National Commission for Scheduled Castes. The functions and responsibilities of the commissions are as follows. For Scheduled Castes, okay. So, to investigate and monitor all matters relating to the safeguard provided for the Scheduled Castes under the Constitution of India, under any other law or under any order of the government, and evaluate the working of such safeguards. Next point, to inquire into specific complaints with respect to the deprivation rights and safeguards of the Scheduled Castes. Next point, to participate and advise on the planning process of socio-economic development of the Scheduled Castes and to evaluate the progress of their development under the functions of the Union and any state. Next point, to present to the President annual reports and other reports upon the working of those safeguards. Next, to make in such reports recommendations as to the measures that should be taken by the Union or any state for the effective implementation of those safeguards and other measures for the protection, welfare, and socio-economic development of the Scheduled Castes. Next, and to discharge such other functions in relation to the protection, welfare, and development and advancement of the Scheduled Castes as the President may, subject to the provisions of any law made by Parliament, by rule specified. Powers of the Commission. The Commission shall, while investigating any matter or inquiring into any complaint, have all the powers of a civil court trying a suit in respect of the following. Point 1. Summoning and enforcing the attendance of any person from any part of India and examining him on oath. Next, requiring the discovery and production of any documents. Next, receiving evidence on affidavits. Next, requisitioning any public record or copy thereof from any court or office. Next, issuing commissions from the examination of witnesses and documents. Next, any other matter which the President may determine. The Union and every state government shall consult the Commission on all major policy matters affecting scheduled castes. Inquiry into specific complaints. The Commission is required to inquire into specific complaints with respect to the deprivation of rights and safeguards of scheduled castes. In order to enable the Commission to perform this function effectively and efficiently, the Commission would like the members of scheduled castes to know, so that it would be easier to inquire into their grievances if they file substantial complaints with supporting documents and quote the relevant protocol of the act or rules which has been violated. Inquiry into cases of atrocities. Whenever information is received in the Commission about any atrocity against a person belonging to scheduled castes, the Commission would immediately get in touch with the law enforcing and administration machinery of the state and the district to ascertain the details of the action taken by the district administration. The Commission ensures the following by monitoring and giving instructions to the concerned authorities. Point 1. Whether the scene of occurrence of the crime has been immediately visited by collector and superintendent of police on the receipt of information. Next, whether proper FIR is registered in local police station. Next, whether names of all persons involved or cited by the complaint person has been included in the FIR. Next, whether an investigation has been taken up by a senior police officer as per provisions of SCs and STs Prevention of Atrocities Act. Next, whether culprits has been apprehended and booked without loss of time, whether proper charge sheet is filed, whether the cases are tried by the special courts, whether special public prosecutors are appointed to handle these, whether police assists the courts in bringing forward witnesses and see that the culprits are suitably punished by the courts. The Commission will also monitor that the victims are provided with suitable medical assistance. Adequate protection is arranged for the victims of such incidents by providing police protection, by stationing a police party, by patrolling, etc. To see that proper compensation is paid to the victims as per provisions of the law. The Commission will, wherever possible, depending upon the gravity and circumstances of the case, visit the place of incident to oversee the arrangements and to console and infuse confidence in the victims. The Commission has laid down detailed procedure for conducting such inquiries and monitoring at all levels. Such inquiries can be conducted by the members of the Commission or teams of investigators from headquarters or state office of the Commission. Next topic, the National Commission for Scheduled Castes. Consequent upon the Constitution 89th Amendment Act 2003, the erstwhile National Commission for Scheduled Castes and Scheduled Tribes has been replaced by National Commission for Scheduled Castes and National Commission for Scheduled Tribes. Functions of the National Commission for Scheduled Tribes now are to investigate and monitor matters relating to safeguards provided for STs under the Constitution or under other laws or under government. Order to evaluate the working of such safeguards, the Constitution of India under its articles provides various safeguards to SCs and STs, educational, economic, social, political and service. To inquire into specific complaints relating to rights and safeguards of STs, to participate and advise in the planning process relating to socio-economic development of STs, and to evaluate the progress of their development under the Union and any state. To submit report to the President annually and at such other times as the Commission may deem fit upon working of safeguards, measures required for effective implementation of programs and schemes relating to welfare and socio-economic development, to discharge such other functions in relation to STs as the President may, subject to the provisions of any law by Parliament as specified. The Commission would also discharge the following other functions in relation to the protection, welfare and development and advancement of the scheduled tribes, namely, measures that need to be taken over conferring ownerships in respect of minor forest produce to the scheduled tribes in forest areas, measures to be taken to safeguard rights to the communities over mineral resources, water resources, etc. by the law, measures to be taken for the development of tribals and for moving viable livelihood strategies, measures to be taken to improve the efficacy of relief rehabilitation measures for tribal groups' displacement development projects, measures to be taken to prevent alienation of tribal people land and to effectively rehabilitate such people in whose alienation has already taken place, measures to be taken to elicit maximum cooperation and involvement of tribal communities for protecting forests, undertaking social afforestation, measures to be taken to ensure full implementation of provisions of panchayats, extensions to the Scheduled Act 1996, measures to be taken to reduce and ultimately eliminate practice of shifting cultivation by tribals that lead to continuous disempowerment and degradation of land and also the environment. Powers of the Commission. The powers of this Commission are as same as that of National Commission of Scheduled Castes. For investigation and inquiry, the Commission is vested with powers of a civil court having authority to summon and enforce attendance of any person and examine on youth, discovery and production of any documents, receive evidence on affidavits, requisition on any public record or copy thereof from any court or office, issue commissions for examination of witnesses and documents, and any matter which President by rule may determine. The National Commission for Women. The National Commission for Women was set up as a statutory body in January 1992 under the National Commission for Women Act 1990 for the following purposes: to review the constitutional and legal safeguards for women, to recommend remedial legislative measures, to facilitate redressal of grievances, and to advise the government on all policy matters affecting women. Functions or activities of NCW. NCW is National Commission for Women. The following are the functions of NCW: investigate and examine all matters relating to the safeguards provided for women under the Constitution and other laws, present to the central government annually and at such other times as the Commission may deem fit, reports upon the working of those safeguards. Make in such reports recommendations for the effective implementation of those safeguards for improving the conditions of women by the Union of any state. Review from time to time the existing provisions of the Constitution and other laws affecting women and recommend emendations therefore so as to suggest remedial legislative measures to meet any inadequacies or shortcomings in such legislations. Take up cases of violation of the provisions of the Constitution and of other laws relating to women with the appropriate authorities. Look into complaints and take on its own notice of matters relating to deprivation of women's rights, non-implementation of laws enacted to provide protection to women, and also to achieve the objective of equality and development. Non-compliance of policy designs, guidelines or instructions aimed at mitigating hardships and ensuring welfare and providing relief to women, and take up the issues arising out of such matters with appropriate authorities. Next point, call for special studies or investigations into specific problems, situations arising out of discrimination and atrocities against women, and identify the constraints so as to recommend strategies for the removal. Next, undertake promotional and educational research so as to suggest ways of ensuring due representation of women in all affairs and identify factors responsible for impeding their advancement, such as lack of access to housing and basic services, inadequate supply to services and technology for reducing drudgery, and occupational health hazards and for increasing their productivity. Next, participate and advise on the planning process of socio-economic development of women. Next, evaluate the progress of the development of women under the Union and any state. Next, inspect a jail, remand home, women's institution or other place custody where women are kept as prisoners or otherwise, and taken with the concerned authorities for remedial action if found necessary. Next, fund legislation involving issues affecting a large body of women. Next, make periodical reports to the government on any matter pertaining to women and in particular various difficulties under which women toil. Next, any other matter which may be referred to it by central government. Point 1. The central government shall place all the reports submitted by NCW before each House of Parliament along with a memorandum explaining the action taken or proposed to be taken on the recommendations and the reasons for the non-acceptance, if any, of any of such recommendations. Next, where any such report or any part thereof relates to any matter which any state government is concerned, the Commission shall forward a copy of such report or part to such state government. The state government places the reports before the legislature of the state along with the memorandum explaining the action taken or proposed to be taken on the recommendations relating to the state and the reasons for the non-acceptance, if any, of any such recommendations. The Commission shall, while investigating any matter, have all the powers of a civil court in respect of the following matters, namely, summoning and enforcing the attendance of any person, room, any part of India and examining him on oath, requiring the discovery and production of any document, receiving evidence on affidavits, requisitioning any public record or copy thereof from any court or office, issuing commissions for the examination of witnesses and documents, and any other matter which may be prescribed. Complaints and Counselling Unit. This cell is the main unit of the Commission and processes the complaints received oral, written, or on its own. Now, suo motu is written in your books in different places, and in bracket the meaning of the same suo motu is explained as on its own. Okay, suo motu means on its own. So the complaints are received oral, written, or suo motu. The complaints received relate to domestic violence, harassment, dowry, torture, desertion, bigamy, rape, refusal to register FIR, cruelty by husband, deprivation, gender discrimination, and sexual harassment at workplace. The complaints are tackled as below. Investigations by the police are expedited and monitored. Relevant data are made available to various state authorities to facilitate action. Family disputes are resolved or compromised through counseling. For serious crimes, the Commission constitutes an inquiry committee which makes spot inquiries, examines various witnesses, collects evidence, and submits the report with recommendations. The implementation of the report is monitored by the NCW. The State Commission, the NGOs, and other experts are involved in these efforts. State visits. The Commission undertakes visits to various states to evaluate the progress or development of women in various states. During the visits, discussions are held with the Chief Minister, the Women and Child Development Minister, the Chief Secretary, the Home Secretary, and the Secretaries of other departments. Seminars and workshops. The Commission conducts seminars, workshops, and conferences and sponsors such events by providing financial assistance to research organizations and NGOs. The important areas so far covered includes violence against women, sexual exploitation of women at workplaces, educational, health and employment aspects, women in agriculture sector, women in Panchayati Raj, custodial justice, mental health institutions, etc. Public hearings. The NCW holds public hearings on issues affecting large sections of women, such as crime against women, women in unorganized labor sector, women in agriculture, and women of minority groups. The deposition at these inquiries helps in appreciating and initiating remedial action. The National Commission for Women regularly extends financial support to NGOs and educational institutions to conduct legal awareness programs to enable women and girls to know their legal rights, to understand the procedure and method of access to the legal systems. So far, 55 legal awareness programs have been conducted. Next topic, the National Commission for Minorities. Now, the National Commission for Minorities, NCM, is a body constituted by the Government of India to safeguard the constitutional and legal rights of the minorities. Essentially, the minorities in India consist of followers of all religions other than Hinduism and weaker sections in the Hindu community. The statutory National Commission for Minorities came into existence in 1993 under the National Commission for Minorities Act 1992. The NCM adheres to the UN Declaration of December 18, 1992, which states that states shall protect the existence of the national or ethnic, cultural, religious, and linguistic identity of minorities within their respective territories and encourage conditions for the promotion of that identity. Constitution of the Commission. The central government shall constitute a body to be known as the National Commission for Minorities, to exercise the powers conferred upon and to perform the functions assigned to it under the National Commission for Minorities Act 1992. The commission shall consist of a chairperson, a vice chairperson, and 5 members to be nominated by the central government from amongst persons of eminence. And 5 members to be nominated by the central government from amongst persons of eminence. Ability and integrity, provided that 5 members, including the chairperson, shall be from amongst the minority communities. Functions. The Commission has the following functions. 1. Evaluate the progress of the development of minorities under the Union and states. 2. Monitor the working of the safeguards provided in the Constitution and in laws enacted by Parliament and the state legislatures. 3. Make recommendations for the effective implementation of safeguards for the protection of the interests of minority by the central government or the state governments. 4. Look into specific complaints regarding deprivation of rights and safeguards of the minorities and take up such matters with appropriate authorities. 5. Undertake studies or surveys into problems arising out of any discrimination against minorities and recommend measures for their removal. 6. Conduct studies, research and analysis on the issues relating to socio-economic and educational development of minorities. 7. Suggest appropriate measures in respect of any minority to be undertaken by the central government or the state governments. 8. Make periodical or special reports to the central government on any matter pertaining to minorities and in particular difficulties confronted by them. And number 9. Any other matter which may be referred to it by the central government. Powers. The Commission has the following powers. Point 1. Summoning and enforcing the attendance of any person from any part of India and examining him on oath. Next, requiring the discovery and production of any document. Next, receiving evidence on affidavit. Next, requisitioning any public record or copy thereof from any court or office. Next, issuing commissions for the examination of witnesses and documents.